Good morning, Your Honors. My name is Craig Anderson, and I represent Police Officer Scott Tompkins. I'd like to reserve 3 minutes for rebuttal, if I may. This is a non-fatal officer-involved shooting where the district court erred by failing to grant Officer Tompkins qualified immunity. The district court, which did not issue a written order, concluded that material facts prevented a proper qualified immunity analysis. In doing so, the district court failed to follow a well-established precedent that in Section 1983 cases, the court's responsibility is to evaluate the facts in the light most favorable to the non-moving party from the perspective of a reasonable officer on scene. If they had done this, they would have had no alternative. The court would have had no alternative, but rather to conclude that it was a reasonable shoot, or at a minimum, the law regarding the shooting was not clearly established. So, as in all these officer-involved shooting cases, they're very factually intensive. Here, you can accept all of the plaintiff's facts as true, which I have to do, and it makes the shooting reasonable. Plaintiff Celeste Diaz was at home and had been drinking. Coincidentally, a routine traffic stop was occurring outside of his home.
That traffic stop itself seems somewhat highly questionable.
Luckily, they're not plaintiffs.
Yes, you are lucky they're not plaintiffs.
Yeah, so.
And also, there's no mention of the whole issue of the Officer Tompkins entering the curtilage of this home without any probable cause at all.
Okay, well, when you talk about his entry, okay, when he.
And what is he doing? It's 2:30 in the morning, and he's sort of wrongfully stopping a Mercedes because it's a Mercedes in the wrong neighborhood, and then he hears a noise, and he doesn't even call for assistance, just walks into somebody's yard. What is he doing?
There was a call of a suspicious vehicle. He saw a vehicle that he believed matched the description. He pulled that vehicle over, happens to be in front of Mr. Celeste Diaz's home. At this time, Mr. Celeste Diaz is in a chat room. It's called an insult chat room. So even Mr. Celeste Diaz admitted that if you were outside his home, you would have thought there was a potential domestic violence incident going on. Mr. Celeste Diaz admitted that. Okay, that's at pages 216 and 217. So,
could there have been yelling without a domestic violence situation going on?
Absolutely.
Was there other noise, like sounds of someone being hit, or?
Well, no, it wasn't. It was just screaming, yelling, profanity. And like I say, Celeste Diaz admitted, he goes, if I was outside my home, I would have thought it was a domestic issue. Now, the two participants in the traffic stop also agreed that it was rather concerning. And the officer, in entering the curtilage, he was walking to the front door. And you've had a rash of Supreme Court decisions.
Well, yes, he could knock on the front door.
Do a knock and talk, absolutely.
Yes, knock and talk. He could have done that.
So there's absolutely nothing unconstitutional about
But he didn't do that.
Well, that's because as he was walking to the door, the garage door begins to open. And that redirects his path. So he is walking to the front door, and then all of a sudden the garage door begins to raise. So he begins to identify himself as a police officer and move towards that direction to address the person opening the garage. Now, and I understand what you're saying with these questions. I don't think it's relevant because he has a lawful right to be on the property. So at that point, he can go up and have a consensual encounter with Mr. Celeste Diaz. And I do believe he has reasonable suspicion to be investigating what's going on inside the home.
What's so unreasonable about what's going on? I mean, I don't understand that.
Well, the fact that you're hearing, and no one could testify exactly as to what was being said, but you have this
You hear loud noises. You hear raised voices.
Yeah, you hear raised voices, but the plaintiff himself has admitted, if I was the police officer, I would have thought it could have been a domestic violence situation. And as an officer, I know that we're looking now with 20/20 hindsight, but he has an obligation to investigate what could be a potential felony going on. If he hears that, what's the unconstitutional nature of walking up and just making sure everything's okay? What are the ramifications if he doesn't, and it is a violent encounter, then I'm here on a different case. You were right outside my house, you heard the screaming, and you didn't do anything. So I don't see a problem with the officer approaching the home. In fact,
okay, so let's get to the garage is coming up. Mr. Celeste Diaz has his long gun, and what does the officer do?
Okay, he's got an assault rifle. Let me tell you what Mr. Celeste Diaz has happened. He says he's crouched down. He's got the gun pointed at the 7 o'clock angle. Okay, so the gun is pointed towards the ground, but towards an angle. And let me remind you that what Mr. Slias-Diaz said is his initial thought when he grabbed his gun to go outside.
He was being robbed, or his car was being stolen.
He says that, but he also says right after the event, okay, in his voluntary statement, that he thought someone had called the cops on him because of his screaming. Now, he changed his story to later on when litigation started that he thought his car was being robbed. His initial statement was, I thought someone called the cops on me. Okay? So anyway, he's crouched down, the garage door is coming up, he admits that he sees the red and blue lights.
But what did Officer Tompkins do? He said, put down the gun, right?
He's identifying himself as a police officer, and then initially, as the garage door comes up, he then says, drop the gun.
Right, and what does Mr. Solis do in
He
response
stands
to that?
up, the best I can give you is what they admit happened, okay? And here is what the plaintiffs say. This is on page 11 of their brief. Solis denied that he intentionally pointed the rifle at the officer. At his deposition, he described how the gun barrel pointed out, and when he was crouched down, and then he changed his position from crouching down as the garage door was rising to stand up. It moved and pointed outward with this movement. So what Diaz says is as he stood up, the gun came up with him. And obviously, you're going to go to where the voice is. So he admits that he stood up and pointed that rifle in the direction of the officer, which Officer Tompkins testified to, and the two witnesses also said that the gun was aimed at Officer Tompkins.
But then wasn't Mr. Solis-Diaz trying to comply with the order?
He then says
That's the problem.
He then says he recognizes the orders and waits another 3 seconds. That's his estimate. To drop the gun, and then he doesn't want to drop it because of the value of the gun, so he proceeds to set it down. But from a perspective of a reasonable officer, that gun is coming up and at him. By that point, Mr. Slias-Diaz admitted, Tompkins is retreating and firing. You know, that he begins, as soon as that gun begins to be lifted in his direction, he begins to fire and retreating. So, Tompkins is running away.
Okay, so why isn't that a material dispute of fact?
Because
what was really going on?
Because the law of this circuit is, once someone points a long rifle in your direction, it is reasonable to respond with deadly force. And the cases are Scott v. Heinrich, Long versus City and County of Honolulu, and you even have recent cases where the court has not found qualified immunity, like Morris versus George or Georgia versus Morris, where the court has said, if you point a gun in the direction, it's reasonable to fire.
So, is it clear that, or is there no dispute that as the garage door was going up, the officer could actually see him standing?
Yes, the officer saw.
Because Solis-Diaz said that he was crouching, trying to look out the bottom of the garage door as it was going up.
Yeah, he's crouched down, and then as it goes up, Solis-Diaz rises with the garage door. And so as he comes up, obviously, it's common sense, and plus Mr. Solis-Diaz agrees, the gun comes up with him. And he's looking in the direction of the officer, because of course the officer is issuing verbal commands. And what's interesting here is Tompkins did not have his weapon drawn. Okay, he's not escalating the situation. He's not, coming up like they did in Scott v. Heinrich, where the officers approached the door with their guns drawn. He draws his gun once he sees the rifle, completely reasonable. And then as that rifle's coming up towards him is when he begins to retreat and fire. And those are undisputed facts. And the district court, nor the plaintiff, has ever given a clearly established case that would have put off.
Is the officer's testimony that he begins shooting as soon as he sees Solis-Diaz begin to stand up with the gun?
As soon as the gun becomes pointed in his direction, he begins to retreat, he pulls, and he's shooting from his hip.
I thought there was some dispute about when Solis-Diaz began to put the gun down on the ground.
There's lots of disputes because Mr. Solis-Diaz has told numerous different stories, okay? That's why I go with page 11.
What did he testify to at his deposition?
Well, what he testified to at his deposition was that he never left the crouching position, and he was just setting the gun down and raising his hands. Now, you move in.
Why isn't, so if you take that version as true, why are you entitled to qualified immunity?
Well, they don't even.
Why are you?
They don't even accept it as true, Your Honor. On page 11 of their brief, they admit that he was rising up and pointing the gun. You're moving into kind of the sham affidavit area here.
The district court didn't go that way, though.
District court didn't go anywhere. They didn't even do a written order. And
Well, there's nothing wrong. You can make a ruling from the bench.
yeah, you can.
As a district
but
judge.
we don't
Her
really
ruling is pretty long as well. I mean, it's pretty thorough.
I'm just saying we don't know why. I don't know what clearly established law there was, because the facts that she said prevented summary judgment were these environmental factors, like that could he hear the commands, could he see the officer, which Solis Diaz admitted that he heard the officer and that he recognized right when it was coming up it was a police officer there. So she never, the judge never ruled that that was the reason that she didn't grant qualified.
But we do it de novo anyway.
You do it de novo. That's why I'm avoiding the order. But on page 11 of their brief, they admit that he was right, that he was raising, and that the gun pointed upward and outward. And I do believe in his depo, he agreed with that later on at, it's on page 278, I believe, of the record, that, and I believe that's his deposition.
I thought that was the one of the main factual disputes about just where he was when the firing began.
Well, we know that he was standing.
Because there was some testimony, if I recall, that, those garage doors that go up in panes,
Yes.
kind of? There was some testimony that the lower part of the garage door had bullet holes in it.
Yeah, there were 2 bullets that went through the bottom. It was 14 seconds, I believe, is what they timed it for, that it took that garage door to open. I mean, this is an event that happened, within 14 seconds. We can tell from that. But
So, in other words, that we don't know exactly at what point that garage door was when the shots were fired, right?
correct, we know it was going up.
We know it's going up, and he testified that he was on the ground, or crouching, not on the ground, but
Well, he was crouching.
trying to look out. I mean, I've done that myself.
Yeah.
In the garage, you try to look out as the garage door is going up, and you get down and you look out.
He's crouching, looking out with an assault rifle. He stands up with the garage, and it's admitted that the gun went upward and outward. There's really no dispute that
Did the officer testify that he was standing, that Solis Diaz was standing up, fully upright when the shooting began?
That's Solis Diaz's testimony. That is on 317 to 318. Okay, that's his criminal testimony at the criminal trial. That he was fully standing up, the gun, and then he decided that he was going to put it down slowly. And all the bullets were being fired when he was holding the gun. Now, at the criminal trial, at his deposition in the civil case, the gun's on the ground, he's raising his hands. He's told too many different stories to really, but he has said under oath he was standing up with the gun.
What was he charged with? I forget.
I believe he was charged with assault on a police officer.
He was acquitted of
He was
that.
acquitted.
Acquitted because the issue is intent. And if you go back to what I read you on page 11, they're arguing this as the criminal case. Solis denies that he intentionally pointed the gun.
So,
That doesn't matter for the purposes
he
of
also
this.
said he was running away, or first he surrendered his left hand up, and in fact his finger was shot. And then he was running away and he was shot in his buttock. So he was turned around from the officer. How could he possibly have been a threat at that point? He was going away from being shot at.
The officer died shots very rapidly. There's no expert testimony here as to how these shots impacted. Obviously, if you get hit in the hand, it can turn you. And there's no evidence that a shot was downward at him. I mean, all these shots occurred just boom, 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 boom. And that's Solis Diaz's testimony. And that takes you into Wilkinson v. Torres, which, you don't look at the number of shots, you look at whether it was reasonably firing in the first place. And I got about a minute.
You want to save it?
I'll save it. I'm sure you have questions. Thank you.
Thank you.
Good morning, may it please the court. Kirk Kennedy for the Respondent Counsel. I actually was Mr. Solis's attorney for the criminal trial, where he was acquitted in front of a jury of 12 in Nevada. So he had the luxury of almost being killed, but then tried as a criminal with assault with a deadly weapon charge. It's a 1 to 6 year felony in Nevada. And we tried that case, and the factual record in that case is very much, it's duplicative of what this federal case is all about. It's the same set of facts. And I can tell you that, from those facts, Mr. Solis Diaz was very fortunate to be alive today. This garage issue was an issue in the criminal trial, and it's an issue in this trial. Mr. Solis Diaz, he was just sitting in his own home, the privacy of his own home, at 2:30 in the morning. His wife is out working, his 2 girls, his daughters are sleeping, and he's in a little office area just goofing off on the internet, and he has his door cracked so he could let some air in, and it was out of this cracked door that these voices are heard out on the street. where Officer Tompkins had pulled over this vehicle. Mr. Solis Diaz had no idea what was going on. That area of town is not exactly the best part of town in Las Vegas. He went and retrieved a lawful SKS rifle that he has no felony convictions, no prior criminal record. He passed the background check for that. He brought that rifle out, put a magazine in, did not load a chamber in the round. He brought it out facing what he thought was an unknown, possibly someone going to steal his wife's white Dodge Durango in the driveway. It's very crucial here, factually, what happened, because when he goes out in the garage of his house, he steps out the door from the inside the house to the garage, which of course is closed, presses the button. It's one of these old chain garage doors. I don't know if you have one or not, where the chain makes a rattling noise as it's opening. He's walking into the garage, it's a very short garage, and as it's going up, as Your Honor pointed out, he was crouched down looking out, and he was holding this gun on a shoulder, a holster, a sling. And so as he's going down, leaning down, this gun, it was a long gun, was leaning out, and that's what Officer Tompkins saw as he's in the driveway, starting to walk up the driveway. And so it's a strange simultaneous sequence of events. As the garage door is going up, Mr. Solis Diaz has no idea who's out in his driveway. There's all this background noise from the garage door opener. He's looking out and he sees the intense light from Officer Tompkins' flashlight, which is attached to his Glock pistol. It's one of those attachments on it, and it's pointed right at him. He can't see a thing. It's 2:30 in the morning. And as the door's going up and he sees someone with a stranger with a flashlight on him, then Mr. Solis looks over and sees the lights from the patrol car of Officer Tompkins over there on the north side of his lawn, and realizing, okay, it's a police officer, he starts to put the gun down, and all hell breaks loose, and all the shooting started. And, I think it's very telling where Mr. Solis was injured. He was injured not just on a finger, he was injured through and through on his right hand. It went in on his palm and out. He was raising his hands up, stop, don't shoot, I surrender, and acquiescing to the officer's commands, and he gets shot through and through. It wasn't a graze on the side, it was through and through. He had his hand up in the air, and to put it even more on there, he turns around and gets shot in the back. He wasn't fleeing anywhere, he's in his garage. He's not running anywhere. He wasn't committing any crime. And when you look at those Graham versus Connor factors, the main one that Judge Dorsey focused on was, did he pose an immediate threat or not? And that's where Judge Dorsey listed half dozen factual issues that she found on her own. I appreciate the fact it's de novo review that supported the denial of summary judgment, just on these facts. There's just too many facts. She never even got to qualified immunity because she couldn't get there because of the factual issues related to whether there was excessive force or not. And so for those reasons, I think the district court got it right on this, and I'd ask the court to uphold and affirm her decision.
So if you take it from the perspective of the officer, he sees the garage door going up.
Yes.
And he sees that gun. And, from his perspective, it's pointing at him.
I appreciate the fact it's a split-second thing. I've been in that driveway, and you know what? The officer testified, he had cover. He had cover right behind that Dodge Durango that was in the driveway. So instead of taking cover, he has this gun out already because he's got the flashlight on. He starts shooting, going across the driveway.
He doesn't have to. We look at what he did and ask whether it's reasonable.
Sure, and it's easy for us to sit here and second guess.
Force, but we're not supposed to try and second guess that.
Sure. But, okay, was the force reasonable? 1 or 2 shots maybe to take a suspect down, but 9 shots.
If they use one, it doesn't make any. If they use one or if it's rapid, 1 versus 9.
Well, this weapon, he's has to pull the trigger each and every time. It's semi-automatic. That requires some amount of thought, even if it's a short duration. This was a matter of seconds, not as few seconds as the case before me, but this garage door was going up. To answer your question about the bullet holes, it's a 3-pane garage door. And as it's going up, the first 2 shots, and we know this are the first 2 shots, hit the lower pane. As it's going up, as it's rising, the first 2 shots hit the lower pane. The other 7 shots are flying into the garage. 2 of them nearly kill him. With his daughters inside the house. And his daughter comes out and sees her dad lying there in the garage in a pool of blood. And to top it off, Officer Tompkins puts his boot on his neck or his back once he's laying there nearly dead, just to add some good measure on there. So, look, Officer Tompkins is not some sort of heinous individual. And I appreciate the fact that police officers have a very difficult job to do. And here we are, judges and lawyers, sitting here thinking about what they did, whether it was right or wrong. But when he
took action of going into the driveway. I appreciate the fact he may have been frightened in seeing what he recognized. He testified at the criminal trial. He recognized, that was an AK-47 type assault rifle. He knew what it was. He had options there. He had options of getting cover. He had options of calling for backup. He had a number of options. He was yelling, drop the gun, drop the gun. Of course, this is the same time frame where this garage door is going up, making all this racket and noise. And Mr. Solis is looking out, seeing what the situation is, puts the gun down, puts his hands up, gets shot through and through. I mean, those are the facts. Those are the undisputed facts of how this thing played out, at least in the criminal trial that he won. So, it's our contention that 9 shots is definitely unreasonable in this situation, especially shooting someone in the back who's not fleeing. He didn't go anywhere. He's in his garage. He didn't try and run in the house. He turns around with his hands up, and that's testimony at the trial and his deposition, and his gift for turning around is a shot in the back. You know, could have paralyzed him. Now he's got $200,000 worth of medical bills and permanent injuries.
So, but what did the officer see? What's the testimony what the officer saw?
The officer is coming up the driveway at the same time as he never made it to the side of the house where the front door was, Officer Tompkins. He starts to walk up the driveway the same time frame that Mr. Solis pushes that button and the garage door starts going up, and Mr. Solis starts looking out, and it's all, you could say, simultaneous. He's walking up, but he's near the Dodge Durango when he sees what looks like the silhouette of this gun. Instead of taking cover behind the Dodge Durango and maybe assessing the situation, that's when everything broke loose and he started shooting. What he did, the testimony was, Officer Tompkins said, drop the gun, drop the gun. He also claims that Mr. Solis said, F you. And again, Mr. Solis, he doesn't know who's even he's facing in this driveway until the door gets all the way up and he looks over and he sees, oh my gosh, it's a police officer. He's coming to this conclusion while he's nearly getting killed. If there's any more questions, or... Well, thank you very much. I appreciate it. Thank you.
I think there's a couple of important points there. One that I failed to touch on was Mr. Solis Diaz has admitted that when he heard the commands before he dropped the gun, he did respond with an expletive. And, you know, that... Well... Yeah, but I mean, it shows the time that was involved. He had time to, say, who the F are you, or F you, whichever he recalls. Now, what was interesting about the argument there was there's a concession that 1 or 2 shots was reasonable. If that's the case, then they're all reasonable. And then you fall into the clearly established element because we have Wilkinson versus Torres, which says we're not going to look at the number of shots. We're going to look at whether the initial decision to shoot. Now, if there's a gap in time, of course, or...
I didn't understand counsel be conceding that anything was...
Oh, maybe I misunderstood. Yeah. I heard 1 or 2 might have been okay, is what I thought I heard. I wrote that down, but maybe I missed that. And then the argument regarding tactics is irrelevant. What he could have done, what he should have done. That's the Billington case. I think what's important...
But what facts do we got? So now you've got me very confused as to what are the operative facts, because... between the two of you.
Here's all I think you need to know. You need to look at page 11 of their brief, and there's the admission that when he rose up from the ground, he moved the gun and pointed it outward. That's consistent with officer...
Oh, no, he's saying that, but what did the officer see? I mean, did he see a gun pointed at him? Or did he... So, for the big question I have is, was this an officer who simply panicked? Or was it an officer who was acting reasonably in response to his perception of events?
Thank you, Your Honor. Officer Tompkins has always testified that the gun was pointed at him, page 110 of the excerpts of the record. Both of the witnesses, Redmond and Tolopi, both said the gun was aimed at Officer Tompkins. So you have all 3 witnesses saying the gun was pointed.
There are 2 witnesses?
Redmond and Tuolape.
Who were they?
They were the individuals from the car stop.
They're still there?
Well, they performed a U-turn and then were in front of the house, and they heard the profanity and they saw the rifle aimed at the officer. And so you have the 3 witnesses, including Officer Tompkins, saying the gun was directed at me, aimed at me. You have the plaintiff saying, as I was standing up, the gun moved and pointed outward. So you basically have an agreement, a consensus here that the gun was moving in the officer's direction.
Did Officer Thompson testify that the gun was actually, that he was actually pointing the gun at him, ready to shoot?
I have that the gun was pointed at him on excerpts of the record, page 110.
In such a,
Yeah, the gun was aimed, that it
like
was
he was
coming out.
holding it ready to shoot. He testified, I'm sorry. I think I'm in trial court. He just said that when Solis Diaz picked up the weapon or the gun, he slung it over his shoulder.
I don't know where that's at in the record. I can say I have not seen that in the record. The testimony that I think is most important is from Solis Diaz's deposition 238 to 239.
Why isn't the most important testimony the
Is it
Officer Tompkins' testimony?
Well, because I have to accept Solis Diaz's testimony is true for here. I think Tompkins' testimony is very important, but that's for trial. Here,
See, that's what creates the issue of fact for me.
well, but here what we have is everybody agreeing the gun is moving outward and upward. And that takes you into Scott v. Heinrich. It takes you into Long versus County of Maui, where once a rifle is pointed at you, or rising, I mean, we have cases that recently came out, like the Torres case? We have the Cruz case, where the justices said on that panel that if you even reach where a gun could be hidden, it's reasonable to fire. If you just reach for it,
It's reasonable to kill someone?
it's reasonable
If
to
someone's
respond.
reaching where a gun could be hidden?
Cruz versus City of Anaheim. It's Judge Kaczynski, and what he says is if the person reached towards his waistband, doesn't have to have a gun, but if they reach there, that's the dispositive issue as to whether you can respond with deadly force. And that is a 2014 case, because once you make that movement towards where a gun could be concealed, you don't have to wait for the other person to fire. You don't have to wait for the other person to produce the gun. It just has to be a reasonable belief that that's what they're going for. And so that was Cruz versus City of Anaheim, which was after this case. But it shows the status of the law in this jurisdiction. And in that case, qualified immunity was not granted because it was an issue of fact as to whether he actually reached for the waistband. But the judges said if he did, clearly it's reasonable to shoot at that point. And here you have an assault rifle being raised and pointed in your direction.
They said it was reasonable to kill, not to shoot at the arm, do a lesser.
Well, I'll tell you that officers are not trained to shoot anywhere but center mass. And so it's not shoot to kill, it's shoot to stop the threat. And so they're not shooting to kill, they're shooting to stop the threat. They're trained to shoot center mass. They don't shoot at knives, they don't shoot at guns, they don't shoot at legs, they don't shoot at arms. They shoot at center mass every time. That is the training. And so I think the fact that the gun is being raised and being pointed is sufficient to grant qualified immunity, and you'd find no clearly established law telling you otherwise. There's not been one case cited to by the plaintiff or the district court that would have put Officer Tompkins on notice that it is unreasonable to use deadly force when a long-arm rifle is being pointed in your direction. Any other questions?
No. So Solis Diaz versus Tompkins will be submitted.